Dear Professor Riewitz, dear colleagues, ladies and gentlemen, thank you very much for this kind invitation and for allowing me to take the floor. I'm very honored to speak to you about the German Enforceable Notary Act in cross-border transactions. European unification has given rise to an increasing number of private law contracts concluded by parties from different member states. However, not all contracts are executed as initially intended by the parties. Every now and then it is necessary for the creditor to recur to enforcement, and even more if the debtor lives in another member state or holds assets there. For this reason, it was very important for European unification that reliable provisions on cross-border enforcement were established. Ladies and gentlemen, first of all, I will give a short overview of the legal framework in Germany for the enforcement of the Notary Act. Then I will go into this in more detail with the help of a practical case example where a German Notary Act has to be enforced abroad. The legal framework in Germany is of particular importance if a German Notary Act was established and the related assets are located in Germany, whereas the creditor or debtor lives abroad. According to the German civil procedure, the Civil Procedure Code, state enforcement is only allowed if there is an enforcement order. And in fact, the court judgment is of course a regular enforcement order. However, a Notary Act can also play a major role as an enforcement order. The notary's competence to draw up notarial enforcement instruments arises from its function as holder of a public office. The decisive provision applicable to notarial enforceable instruments under German law is section 794, paragraph 1, number 5 of the German Code of Civil Procedure. This provision defines the prerequisites for a notarial enforceable instrument, called also a declaration of submission. And these prerequisites are the following. Firstly, the instruments must be established by a German notary within the official competences and under the prescribed form by authentication. Secondly, there must be a certain type of substantive claim. For instance, the obligation to make a declaration of intent would not be considered as an appropriate claim. Furthermore, tenancy of residential premises is not covered either, since the aim is to protect people's homes as centers of life, and therefore you cannot submit yourself under immediate enforcement. But the most common claims, of course, which can be subject to such a notarial enforcement order, submission to immediate enforcement, are claims to pay money, claims for money, and for claims of money for mortgages. The notarial enforcement order is of crucial importance in practice. Thirdly, third prerequisite for such a notarial enforcement order is that the debtor must subject himself to immediate enforcement with regard to the claim. This declaration forms the decisive element of an enforceable notary act in Germany. In other words, compared to other countries, for example, to France, a German Notary Act is not automatically enforceable, but must be accompanied by a declaration of submission to enforcement. In practice, enforceable notary acts are of paramount importance. On the one hand, they considerably relieve the courts. On the other hand, they offer the creditor the possibility to obtain the enforcement order quickly and at low cost. And as I said, for example, each and every mortgage in Germany is subject to such a notarial enforceable act, that's the main scope of application, but also all kinds of claims for payments can be included and are included in practice in notarial enforceable deeds. For example, in each sales contract, you have enforceable claims for money. As with any other enforcement procedure in Germany, the other prerequisites for enforcement must be met in addition to the enforcement order. In particular, the so-called clause of enforcement and the service. The clause, the enforcement clause, is issued in a so-called clause procedure. In this procedure, it is checked whether the enforcement order is formally enforceable. This procedure follows the authentication procedure, which is also carried out by the notary for notarial instruments. The result of this procedure is the enforceable copy of the authentic instrument. This is a copy of the instrument with the so-called enforcement clause. It is also worth mentioning that in the clause procedure, the notary does not act as an authentication body, but in a judicial function. In this procedure, the notary must make the right decision. He is not subject to any advisory or assistance duties. Rather, the notary acts similar as a judge who decides independently on each and every application to obtain an enforcement clause for a court judgment, for example. The notary who holds the instrument in safe custody is exclusively competent for issuing such an enforcement clause, and principally this is the notary who has also drawn up the instrument. In order to be able to enforce against the debtor, service is also required in addition to the title and the clause. And this means the enforcement order must be sent to the debtor by official ways. The purpose of this requirement is twofold. It helps the debtor to be reliably informed about the circumstances of the upcoming enforcement and to protect the debtor's right to be heard in the enforcement proceedings. Also, the service of the debt security constitutes a last warning to the debtor and might encourage him to pay or to perform voluntarily. Ladies and gentlemen, this brings me to the question of how service is operated if the debtor resides abroad, but the assets are located in Germany. The service is the exercise of an act of sovereignty. This means that German authorities can only ensure the service abroad with the consent of the foreign state. Two legal acts are decisive here, which have considerably simplified the service procedure in cross-border transactions. On the one hand, there is the European regulation on the service of documents of 2007, which applies to the service within the territory of another member state. The document to be served must be handed over to the district court, which in turn forwards it to the receiving state and the responsible authorities there. Therefore, notaries cannot directly service documents abroad. If service to a third country is concerned, the Hague Service Convention of 1965 applies. Only if the three conditions I mentioned before are met, title, clause, and service enforcement can be executed. Let us now turn to cases in which a German notary act has to be enforced abroad because the relevant assets are located in a foreign country. The principle is that a domestic enforceable title cannot be enforced abroad without the involvement of the concerned state. Therefore, enforcement in a state other than that in which the title was established is prohibited as a general rule, as you all know, under public international law. Enforcement is a sovereign task, and therefore the principle can be considered as a result of the sovereignty of states. The involvement of the executing state, which is required in principle, serves two purposes. Firstly, the purpose is to ensure a structured and unambiguous presentation of the enforceable content in a language comprehensible to the executing state. Secondly, it provides for control of the content. Enforceability is in general impossible if the corresponding foreign law does not know the institution that is responsible for the enforcement of domestic notarial instruments. This is the case in Anglo-Saxon law, for example. Therefore, for instance, German notarial enforceable instruments cannot be enforced in the United States. In the context of the civil law notariate, however, especially in continental Europe and South America, notarial instruments are in principle enforceable. Special submission to enforcement, as it is required in Germany, is not necessary. Therefore, intergovernmental regulations are decisive for enforcement in cross-border transactions. For EU member states, The so-called Brussels 1A regulation, as an act of secondary union law, is the most important regulation which substitutes within the European Union international conventions and intergovernmental regulations. Fortunately, because this makes life much easier for creditors within the European Union. The regulation, the Brussels 1 regulation, is directly applicable in the member states and has Brussels 1A, excuse me, it has replaced the Brussels 1 regulation and the Brussels Convention on Jurisdiction and the Enforcement of Judgments in Civil and Commercial Matters of 1968. Ladies and gentlemen, the year I just mentioned shows that the need for intergovernmental regulations was recognized already at an early stage more than 50 years ago. The prerequisites have been revised again and again over the years, and enforcement in European countries has, of course, been continuously simplified. Indeed, according to the Brussels 1A regulation, an authentic instrument that is enforceable in the member state of origin is also enforceable in any other member state without the need for a declaration of enforceability. Before I come to further details of the Brussels 1A regulation, I would like to briefly address the question of what exactly is an authentic instrument. The Brussels 1A regulation, as well as other EU legislative acts discussed today, use this term within the meaning of the definition of the European Court of Justice laid down in the Unibank decision of June 1999. So we have a kind of acquis communautaire about the authentic instrument now for 22 years. And according to this judgment, an authentic instrument has to meet three requirements. Firstly, the authenticity of the act should have been established by a public authority or someone who's appointed by the state, like a notary. Secondly, this authenticity should relate to the content of the act and not only, for example, to the signature. And thirdly, the act has to be enforceable in itself in the state in which it was established. These are the three requirements under the Unibank judgment and under the Brussels 1A regulation. Now coming back to the Brussels 1A regulation, a notarial instrument enforceable in Germany no longer requires a separate declaration of enforceability for enforcement in other member states. All which is required is a certificate established by the German notary, the so-called enforcement certificate. An enforcement clause, according to our national law, is no longer required. The notary must serve a copy of the certificate on the enforcement debtor ex officio. In principle, the enforcement state does not verify the content of the German instrument. However, the enforcement debtor is not defenseless against the enforcement. The Brussels 1A regulation provides him with a legal remedy against enforcement. Therefore, the debtor can request the court in the executing state, which is normally his home state, for non-enforcement. If, however, the enforcement debtor does not lodge such a remedy, does not file such a remedy, the executing state, the country of destination, does not intervene at all with regard to the enforcement order. The enforcement of notarial enforceable instruments in other EU countries is thus considerably simplified and sped up and facilitated by the Brussels 1A regulation. As a comparison, the previous regulations still provided that a so-called declaration of enforceability is required for the enforcement of an enforceable notary act. According to this, in the past, the creditor had to get the instrument enforceable in the executing state within an exequatur procedure, but this has been now abolished. Therefore, there's no further control by any court or other authority which would check the merits of the claim and the compliance with procedural rules before enforcement. Right. In the context of the Brussels 1 regulation, the question of an obvious conflict with public policy is only examined if the debtor in the Brussels 1A regulation lodges a remedy. Since there is no former exequatur procedure, the debtor has to defend himself against such execution. And of course, a simplified procedure is an expression of mutual trust between the member states. We regard the notaries in other member states as equivalents to the German notaries. We regard judicial authorities in other member states as equivalent to our own authorities, to our own courts, and we believe that they observe and comply with the same standards of the rule of law and of due process in the procedure. Another important contribution to the realization of the internal market in Europe in the field of cross-border enforcement has been made or was made by the EU regulation on the European enforcement order. According to this, it is possible, to have certain notarial enforceable instruments certified as European enforcement orders, with the consequence that such instruments can now be enforced in other member states. The European enforcement order regulation is, however, only applicable to authentic instruments containing uncontested claims. In turn, the claim is only considered uncontested if the debtor has expressly acknowledged it in the authentic instrument. The scope of verification when issuing the certification is very limited. It only has to be verified that the authentic instrument is enforceable in the member state of origin. The involvement of the enforcing member state is not envisaged when issuing the certification. The notary competent for the issuance of the certification in the case of German notarial instruments is the notary in charge with the issuance of an enforceable copy. And this is a notary who keeps the instrument in safe custody. Once the notarial instrument has been certified as a European enforcement order, the enforcement can only be refused under very limited prerequisites. The debtor can only use the procedure for rectification and withdrawal according to the regulation, which is governed by Article 10 of this regulation. This means that reasons for refusal of enforcement are no longer examined at any time. And this also applies to any infringements of the public policy of the executing member state, which means there is no control of public policy infringements anymore. This is mainly due to the nature of notarial instruments. They contain enforceable claims established contractually or unilaterally by the debtor, which means only with the consent of the debtor, and therefore one may argue that such waiver of any control, even of the control of public policy infringements, can be waived in the procedure. Another relevant legal act at EU level is the European Succession Regulation. This regulation still provides for an exequatur procedure. And again, the declaration of enforceability by the executing state is required. Then I would also like to mention the European Maintenance Payment Regulation. According to this regulation, the decisive factor whether the executing member state will enforce an authentic act is the Hague Protocol of 2007. And if there is a connection, there's a connection to the member state where the instrument should be executed, the creditor only has to apply for enforcement in the member state of origin. If there is no connection, the exequatur procedure must be followed. The fact that in the case of cross-border enforcement, the instruments must undergo a separate, although minimalist procedure, either in the member state of origin or in the executing member state, means that no further formality, such as an apostille or legalization, is required. Major progress has also been made at international level. For example, we have the Lugano Convention of 2007 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters, which applies between the European Union and the member states of the EU member states, Switzerland, Norway, and Iceland. The convention in turn provides for the exequatur procedure for cross-border enforcement. So the Lugano Convention does not go as far as the secondary union law acts. And then we have the Hague Convention of 2019 on the recognition and enforcement of foreign judgments. However, this convention does not apply to authentic instruments, but there's an ongoing debate in the Hague Conference, and maybe one day notarial instruments will be included in this convention, and then notarial instruments would also be enforceable on a worldwide level. Ladies and gentlemen, the notary, as a holder of a public office, is able to confer enforceability equivalent to that of a court decision to a claim, which at first has been merely established by a contract or a unilateral declaration of the debtor. Notaries derive this sovereign function from the member state in which they are appointed to exercise their office. The harmonization of enforcement procedures within the European Union enables European notaries to offer citizens and businesses an enforcement order that can be used throughout Europe without any significant formalities. European notaries thereby make a significant contribution to relieving the courts and to help debtors to claim their money and to get enforced their claims. Thank you very much for your attention.